Good evening, everybody. This is Jonathan. I hope you are all doing well. I'm trying to do this with a headset. I'm not sure if this is going to work right because I'm getting a little bit of echo. Let me know if you're hearing any echo on your end, and I can switch back to the other type of microphone. So we shall see. We shall see. Okay, so let's go ahead and get started. First of all, hope everybody is having a good week and that you are um, basically having good weather wherever you are, and that everything is working well in your life, and that hopefully you have some good questions for about Social Security disability, and I will be happy to try to answer those for you today. So again, please let me know if you can hear me okay. It sounds good on my end, but you just never know. Okay, so let's go ahead and start with, in fact, let me just take a quick look here if anybody has said, okay. Uh, you'll let me know if you can't hear me. Okay, let's start with cancer-free. Ask a very good question. It's a lady who's working on my claim. I assume you're meaning the adjudicator or claims specialist. Know that you meet a listing. I mean, because I can call and talk to her and say that we're really close to being done. Almost 59, I'm not sure, 59.4 liters of oxygen continuously waiting. I think that generally speaking, the adjudicators or claims specialists will know, they're going to look at the medical reports and they will see that you meet a listing. It's always a good idea to remind them of that. I would not assume anything. I think that you just want to continuously remind them of that. So, do they know? Should they know? Yes, but I don't assume anything with Social Security. But again, if you're on oxygen, that should really stand out in the record. I'd be very surprised if they did not know about that. Laura says, Laura's been here before. In my initial app, I stated I fell 6 to 8 times in 2024 due to leg weakness from a pinched nerve. Now I fell and broke my leg. Oh boy, in 5 spots. Will that help my case? 57. Yeah, I think that certainly is evidence of a significant weakness. Now, pinched nerve is not really a medical term. It's probably a herniated disc, or it could be nerve impingement, something like that. So you want to probably firm up the exact diagnosis as to what you've got going on. But yeah, I think that if you are having that many falls and to the point where you break your leg, then yeah, that certainly is going to help your case. Now, what you need to make sure you do, though, is let them know that the falls that you're having are not, this is an ongoing problem. This is not new. Social Security has kind of a nasty habit of sometimes of looking at people and saying, well, we believe that as of today, you're having a big problem, and this is in 2024. And they start trying to mess around with your onset date. You don't want them to do that. So I think this is part of a pattern, is what I'm getting at, of problems. And again, you want to make sure that Social Security is aware that this is part of that pattern. Christina, one of my loyal listeners and viewers, is hello from California. Hello, Christina. Hope you are doing well. Kevin Johnson, what now? Wait time has been 2 years on recon, another 3 before you get approved. I would say, again, my time frame generally is about a year for initial, 10 months, 8 to 10 months for recon, another 5, 6, 7 months for hearing. If you've been at recon for 2 years, you need to get online and contact your U.S. Senator and say, I've been waiting 2 years on reconsideration. That is way too long. Will you begin a congressional inquiry into this? Because that is just outrageously too long. So that's just way too long. And I would do that. So, and again, I don't think that Musk or Trump is calling this show, but I think that there's certainly a lot of chaos right now at Social Security. People don't know whether they're being offered buyouts. They don't know whether they're being forced to come back to work. They don't know if they're going to be there the next day. So it's not the greatest place to work right now. I would absolutely say that. And, there are people leaving. Morale is not good. So, that's just going to continue on for a while until they get this straightened out in some way, shape, or form, whatever that form will be. I don't know. Trish says, hello from Eastern Tennessee. Hello, Trish. I guess you're probably in the same weather we're having here in Atlanta. It was about 72, 73 degrees today and sunny. Absolutely gorgeous day. It's going to rain, I think, this weekend, unfortunately, but, today was really nice. So I hope that you had a nice day as well. Okay, part one. Husband had a hearing and probably denied. I'm guessing that you got that from the questions that were asked the vocational witness. Filed at age 53, initial said light restrictions and semi-skilled stalker SVP4. He turned 55. The ALJ did not mention changing the onset date to age 55. Well, again, I think I would wait to see what the decision says. Obviously, at 55, you have grid rule 202.06 could come into play, and that might make a difference there. Now, again, you hate to give up all those past due benefits, but a win is a win. So, I would wait to see what the decision says. And, again, if he is, semi-skilled, but those skills don't really readily transfer at 55, even if you could do light work, he meets the grid. That sounds like a pretty good argument to me, but wait and see the decision. Part two, do they do that in a hearing or a letter? Should appeal or start an application? At 55, chronic pain. I would wait. Again, it's a little bit unclear. It says probably denied. So I'm guessing you've not gotten the decision. So I would say wait until you get the decision, see what it says. What I like to do is have a colleague of mine who does nothing but appeals look at it. And I think there are a couple of people I've mentioned. I work with Carl Osterhout a good bit, a gentleman named Brian Konoski. There are other people who do it. Adriana, who was on with me a couple weeks ago, De La Torre does it. So there are plenty of people out there who can look at appeals and say, look at cases for possible appeal and say, yes, you've got an argument there. So I think, if you get a denial, I would have somebody, if your attorney doesn't want to do it, have somebody take a look at it, and then you can make a decision. I would also pay a lot of attention to what they call the date last insured in the decision. That's the last day that your husband will be insured for Title II disability. If you wait and you file a new case and it's after the date last insured, there's no disability case. All it is SSI. So you definitely want to take a look at that as well. So my point is that when you get a denial, have your attorney look at it, go over it with you, and you can make decisions about what you want to do. What do I think about Musk calling Social Security a Ponzi scheme? Not a very good choice of words. I mean, I know that there's a lot of, I was reading in the paper even today, that, there's a lot of hostility that Mr. Musk has towards Social Security. There's this whole notion that all these people over 130 are getting paid, which is not true. I think that Republicans need to be very careful about going after Social Security. They call it the third rail of politics, and you know, it's a problem in the sense that for budgeting, that the number of people paying in versus people that are be drawing out, that those numbers are getting askew or being skewed. I mean, realize that Social Security, when it was created by Franklin Roosevelt, was designed to help supplement their retirement. And they got it at 65, and the life expectancy at that point was 67, 66, 67. Now it has been expanded to include disability, SSI, widow's benefits, life expectancies in the 80s. And we also have a problem that the number of workers that are paying in to cover this are not enough to cover what's got to come out. So something has got to happen. Either they change the benefit structure or they raise taxes or some combination of both. The rubber meets the road in 2035. So my guess would be, if I had to guess, and this is just my guess, is that at some point around 2030, Congress, or maybe before then, Congress will change the retirement age, move it up for people who are aged, say, 45 and below. They will increase the wage base that people are paying into Social Security. Um, they may means test Social Security retirement, although that's going to be a tough sell, where people who have a net worth over a certain amount have a reduced benefit schedule, probably for people, that are going to be entering the system, maybe people that are 45 and below. But, who knows? Who knows what they're going to do? I mean, I know that this administration does not have a lot of uh, interest in raising taxes. So, they're going to look. I think, I put this in a couple of videos. They're going to try to do everything they can to root out the fraud. Is there fraud? Yes, there's a little bit of fraud, not a huge amount, but there is some fraud. They're going to go through that. I think they're going to probably put more effort in continuing disability reviews. That's an easy target because, especially for people who are in their 20s and 30s and early 40s, it'll be easy to go and say, well, you are no longer disabled. The way the system is structured right now, very hard to have an attorney with you when you have a CDR hearing, because you either have to choose to keep benefits continuing, which means there's no past due benefits, or you say no money coming out to me while I appeal, which is not viable either. So it's an easy target as opposed to people that are entering the system who can get attorneys on contingency. So it'll be some combination of those things. What and when, I don't know, but that's my guess as to what will happen. All right, Terry Clemens. I had my remand hearing last week. The ALJ made a decision already. Is that good or bad sign? It's, normally I would say it's probably a pretty good sign, but you just don't know. It depends on the ALJ. It depends on the evidence. In my experience, faster decisions are usually positive. I'll just tell you that. But that doesn't mean everyone is going to be like that, but that's been my experience. All right. TE major. If you don't have long to live, I'm sorry, and you file for emergency 6-month PD benefits, presumptive disability benefits, how do you go about if you already have a case pending but your health has declined? I would either yourself or have your attorney reach out to the adjudicator and try to get into the quick disability determination, the QDD program, where they will process it very, very quickly. But I think you need to let the adjudicator know with medical evidence that this is either a TERI, a terminal illness case, a compassionate allowance case, or one that should be processed for quick disability determination. I'm sorry to hear that, but that's what I would do. Stargirl, getting ready to apply, working on the paper trail, but before I apply, would have to apply for SSI first since I can't work, or no? Because no, you apply for both at the same time. The same definition of disability. And believe me, you want to apply for both at the same time, because if you apply for them separately, then you have two separate cases, and hoping they'll consolidate them is not a good thing. Definitely go ahead and apply for both at the same time. Blue Z, I had my SSDI hearing 2 weeks ago. I haven't heard anything. Should I be nervous? No, 2 weeks is nothing. I mean, I'm getting decisions now in cases, that were filed or that I tried a month and a half, 2 months ago. So it could be 4 to 8 weeks before you hear anything. Mark, don't forget to thank you, Mark. And Mark and I have a hearing coming up at the end of this month, and I was working on it just the other day, working my pre-hearing brief. So Mark, I'll be in touch with you with a copy of that shortly. Glenn, where did you hear that from? I think Glenn says the Ponzi thing. That's the Ponzi thing. That was a quote in the paper. I mean, I don't. In the Atlanta paper, there was actually an article, and that was a quote in the paper. So I'm assuming that it's true. Mark is feeling anxious again. Mark, I'm working on it, so I'll have the brief done within a few days, and we'll be talking. But I started working on it this past week. The brief. Blue City Garage. Blue City Garage. Are you in Memphis? Where's Blue? What's Blue City? Call DDS was told next is an eye exam. You have low vision, central serous retinopathy, and choroidal neovascularization. So far, not legally blind. So my medical CE did not go well. No, I mean, I would tell you medical CEs are usually kind of a waste of time in general. Not always, but in general. And the medical doctor who did the CE is not qualified to do an ophthalmologic examination. So if vision issues are a major issue here, then I would say that it's not unusual they would send you out to an ophthalmologist. So I don't think I think it probably just means the doctor in the medical CE said, I'm not qualified to examine this person's vision issues. So he needs to see or he or she needs to see a specialist. I think that's probably what happened there. Calvin H. Good evening. Have you ever had a case in your client had a medical marijuana card for pain? If so, and what was the outcome of those cases we're taking? I frequently see medical marijuana or even marijuana. Sometimes it's not even clear it's medical marijuana. And obviously marijuana is a Schedule 1 drug by the federal government, and it's illegal. My experience has been that disability judges are not too concerned about it, especially if you have a marijuana card, that it's being used for nausea relief or pain relief or whatever the application might be. So I don't think that would be something that would tell me not to take a case. Now, if the person's using meth, that's a big problem. If they're abusing marijuana, using it to get high as opposed to pain relief, that's a problem. But if it's certainly if it's medically ordered, there's a marijuana card, which doesn't mean a whole lot. Obviously, there's a lot of places you can get a marijuana card, but if you're under the care of a doctor who recommended it, that would not stop me from taking a case. I'm going to look at it, but that would not stop me. Vince, how are you doing, Vince? Crispy, 36 degrees here in Davison. Well, it was 72 here in Atlanta, so one of us made the right choice as to where to live. That's all I can say. But enjoy the cool. Enjoy the cool. Yes, Elon Musk did say that Social Security is a Ponzi scheme. Um, you know, um, Again, not a good choice of words because I don't think it's that. I mean, Social Security is probably one of the most popular federal programs that's ever been done. Look, in reality, it was not designed to be a retirement plan. It was not designed to be a disability plan. It was not to be a person's sole source of support. Back in the 40s and 50s, more people had pensions. They weren't living as long. So things have changed and Social Security has morphed into something it was not intended to be. And again, the funding mechanisms were not updated. That's just the reality. So something has got to give. What that will be, I don't know. I know that there's a lot of talk. Charles Hall in his blog talks about that he believes that the goal of, President Trump and Mr. Musk is to privatize Social Security. And I know that President Bush had floated the ideas about partial privatization. And again, I haven't seen the numbers on that. Would that, you know, increase the solvency of the program? Would it be only available to certain people? I don't know. My point is, there's going to be a lot of ideas floated out there, and they're going to have to do something. I don't think it's going to be one thing. It's going to be a combination of things. But again, I think increase in revenue is going to be part of it, and tightening up the standards is going to be part of it as well, I believe. Okay, so you say you can hear me good, Trish. Okay, that's good. Yeah, like I said, I got this big old clunky headset, and I was going to have a guest on tonight, but his computers were not working right, so we're going to do it another time. So when I have a guest, I felt like I needed to use this because, you don't get that echo. So I just said, well, let's try it and see how it sounds. So when I listen to the replay of this, I'll have a better idea of how it sounds compared to my other microphone. Sarah D. is applying right now for chronic diabetes, chronic anemia, PTSD, depression, anxiety. Just injured my knee. I have ligament damage and two small fractures. How much will my knee injury? That is my son calling me. He's going to have to wait. How much will my knee injury help the physical portion of your claim? It's going to depend on whether your knee injury is it's permanent or is it temporary? You have ligament damage, and again, is there going to be a surgical repair? Is this going to be better within a year? Realize Social Security defines disability as a medical problem or problems that individually or together would prevent you from being able to engage in substantial gainful activity for 12 consecutive months or result in death. So a temporary problem, like a banged up knee, is not inherently going to be disabling. But if you don't get the ligament fixed and you have the fractures, or the fix does not work very well and that limits your walking and standing, that would be a factor. The question is, what are things likely to look at in a year? And I would never tell somebody not to get medical treatment so they would make their Social Security case stronger. You want to get your knee fixed. Obviously, if you wait on it, it could make the recovery less viable. So, the real question in my mind is this something that's going to last a year? Obviously the other things, diabetes doesn't go away, the anemia doesn't go away, PTSD does not go away, depression, anxiety. So the question is, do you have enough there? Or, is there evidence to suggest that you've got some permanent damage to your knee such that, you'll be limited to light work or sedentary work, and maybe the grids come into play, or maybe that in combination with the mental health issues would put you over the top. Cassie Marie just had a hearing last week. Worked part-time for 16 years driving a school bus. Why did the judge ask me when's the last time I worked full-time? Um, I don't know. I mean, again, I'm assuming, and I could be wrong in this assumption, that your earnings were SGA, $1,620 gross and 25, or 1,550 and 24. Maybe the earnings were low. Maybe there was an argument put forth that this is the maximum you could do. I don't know. I mean, it's just, I think judges like to get a full picture of somebody's work history, and this is a part of that picture there. But again, I think it's going to really boil down to whether you could do work at the SGA substantial gainful activity level. Bro with fibro, which is, again, I've got a case, a male fibro case coming up. I just finished the brief on it today. It's coming up. I'm not sure it was next week or the week after. It's going to be interesting to see, and whether this will fly, because the guy really has some significant pain. He's been going to the doctor. The doctor's saying it's he's got some mental health issues along with the fibro, that it's debilitating. Got a reasonable judge, so we'll see if that works. But anyway, your mom is a high income earner and she's supporting you, but the medical costs are adding up. Can the ALJ add her income to deny you? No, no, that's her income. Now, if it's an SSI case and she's giving you support, that could be considered, in the deeming calculation. But for SSDI, her earnings have nothing to do with you at all. Okay, and Sarah talks about, this is the person with the knee issue, may or may not need knee surgery to fix a ligament and meniscus. Again, I think at the end of the day, the question to ask is, where will the knee be most likely in a year? And what is that going to look like? And that will certainly, your case will not be ready for resolution in the year. So a year from now, let's see what the knee is looking like, I would tell you. Melissa, on SSI, trying to get SSDI, have severe psychiatric disorder in step 3. How long does the process take in Sherman, Texas? I'm a little, people sometimes email me that I'm a little confused. SSDI is not like a more, I don't know what the right word is, another version of disability. It's not a higher paying version. It's the exact same definition of disability. And SSI is when you don't have earnings records to have enough for SSDI. So if you're on SSI, obviously you're not working. If you were insured for SSDI, I would think you would have applied for SSDI. So if, let's say, you're on SSI for 5 years, you won't have the earnings record to get on SSDI. So it's not like you can get onto SSDI. It's, being on SSI does not qualify you to get an SSDI. Now, if you're going for a widow's benefit claim, okay. If you're going for a disabled adult child claim on somebody else's earnings record, okay. But again, you've already been deemed disabled. So maybe, again, I don't know, say how old you are, but I don't understand the logic, I guess what I'm saying, not being to be disrespectful, but you don't go from SSI to SSD. It's not a progression like the VA has. You get 50%, then you get 60%, 70%. There's nothing like that in Social Security. So, SSI and SSD have the same definition of disability. Randy, how often do we check? We get them every day, so we check all the time. Is that the best way to mess? You've got my direct email, Randy. Just email me. My case is one of the ways we do it. But yeah, just, email me or email Jen directly, I think is probably the best way to get us if you need something. The messaging, we have a number of people, Madeline, who says good evening, checks them. We have 3 or 4 people who check them, and just depending on the work schedules, how quickly they get back. But if you need something, just email me directly. That you've got my email, so I would do that. Hello, Madeline. Hope you're doing well. Okay, so Deb asks, the gentleman who asked about terminal illness in hospice, he's the one, how do you make it go quicker? And I said to reach out to the adjudicator there. What can you tell us about the CRP claims review process? I'm not familiar with that acronym. I'm sorry, Robert. I don't know. I've never heard of that. If that's, maybe something I see it as something else. It's just, the 5-step sequential process, but I've never heard of the quote unquote claims review process. I will look it up, but I'm not familiar with that terminology. Maybe you know it in some other form. Um, Okay, Ms. Crystal says, receive your SSI back pay, which won't be a whole lot of money. SSDI is still being held up with workers' comp offset issues. Yeah, if you're getting workers' comp, let's say that you're on workers' comp, you're getting monthly benefits. Every month you're getting those benefits, it's going to offset your SSI. You won't get any SSDI rather. If you settle your case, there will be language in your settlement that says, we're treating this lump sum as if it was a payout over Crystal's lifespan. And so the reduction will be relatively small. That's probably what they're trying to figure out, is what the amount of the reduction would be. But if it's for months you actually got comp, that'll be dollar for dollar offset, almost always. But it does take a little while for them to figure it out. Mike, do you know why it takes a while for a hearing with the judge? I wanted to ask, is it now being telephone? Um, well, the hearings can be done by telephone or by video. Both of them use Microsoft Teams. The telephone hearings just use the audio portion of Teams, and the video uses the video portion of Teams as well. I find that you can get faster hearings using telephone or video than you can live. It's just, the backup. It's just, although the backup is really not so much at the hearing stage. Normally, when I request a hearing, I get one within 5 to 7 months. And I have a few, like I've had two this week where someone in the hearings office in, I think it's in Houston or Dallas, someplace in Texas, emailed me and she's like, we have a couple of openings. Will you waive a notice and take these two cases? I'm like, absolutely. So it can be done pretty quickly, but it's just because it's got to be, the file has, to answer your question, why does it take a while? The file has to be what they call worked up, which means the staff at the hearing office has to number the file, put it in order, remove the duplicates, get it ready for the judge. And then you've got to give appropriate notice, and you've got to get on the calendar. And so they try to look. I will tell you, like when I get every month, I have to send in or fill out an online schedule to say my availability for hearings 6 months from now. So they're scheduling them out. So in other words, I would file in before the end of February. I think it was for July or August. I can't remember. I think it was August. My availability. So they're trying to make their calendars. They may not have the hearings set quite yet, but they at least know the judge's availability, and so they're setting up things. But they do it in advance because they have to give legally. You have to give a certain amount of notice, but it does not. It does not take much longer, really any longer by phone than it would be. It's faster by phone than it would be live. And right now the default, at least at this point in time, is telephone or video. And I like it. I think it's great. I think it's a lot. In fact, I did a seminar that I taught earlier this week for lawyers getting continuing education credit. And one of the things that I find is that people ask the question about the telephone hearings. Are they as fair? Is it is good? It's just a heck of a lot easier. One of the things I talked about, and I think I probably mentioned this here as well. In Atlanta, where I live, and when I was doing live hearings, I would go downtown Atlanta. Is about a 45-minute to an hour drive from where I live and work. Just because the traffic in Atlanta is horrendous. So I would usually take MARTA, the public transport, the light rail service. But MARTA doesn't run during the day. It runs every like 20 minutes. So that means I would have to get there early, and MARTA is not the most reliable either. So I would usually leave to go to MARTA over 2 hours ahead of time, before my hearing. And I would get there maybe 30 minutes ahead of time. And then I would do my hearing, which would be an hour. Then I would have to come back. So we're talking about 4 to 5 hours of my day if I took MARTA, public transportation. If I drove, I would have to park, and the parking lot near the Atlanta hearing office is $20. which, I'm not a big fan of paying that kind of money for parking. My clients, of course, are not working. They're pursuing disability. To ask somebody to pay $20 for parking is a lot. I mean, that's a, that's a grocery bill. So, the doing the hearings by video has a huge advantage of not putting people in the situation where they have to pay for just, outrageous parking bills, or to take, public transportation if they're not used to doing that. It can be a little unsafe at times. So, I think that the virtual hearings are much better, and that's been my observation, that most my colleagues feel the same way. But I remember we had some discussion about that in my seminar. Um, Michelle is going to be 57 in July. I'm also a July birthday. She works full time, but I'm unsure how much longer I can go. Fused at L4-5, stenosis, degenerative disc disease. Doctor wants to do 2 more surgeries. I also had a total knee replacement, sleep apnea, central and obstructive. I'm very lethargic. Have to take breaks. Have an MRI on my shoulders as well on Monday. Because I have so much pain. I tried pain management, PT, nothing worked. You think of a case, several sick days in VA can take, use it up before I file. Yes, I do think you have a case. Now, again, I always say that with the understanding that not having looked at the MRIs and so forth, is there objective evidence to support all the things you're talking about? But assuming that there is medical evidence consistent with what you're saying, and you're 57, you're over 55, that says that the grid rules probably apply. So even if you have transferable skills, those would be eroded by pain, fatigue, maybe in medication side effects. So, I would say, assuming that the medical data looks good, you've got I think a pretty strong case. It would definitely be one I would look at, because I think that, anybody over 55 with documented objective medical problems, that's usually a very, very good sign for disability purposes. And those cases are I can usually win those cases, because most judges realize that a 57-year-old is going to be not easy to retrain into something else, and that you meet the requirements under the grid rules, which basically say even if you could do light work is defined as standing and walking 6 hours a day, which you probably can't do. Lifting 20 pounds occasion, probably can't do. You are disabled, assuming no transferable skills. And again, I get rid of the transferable skills by looking at the pain, medication side effects, fatigue, things like that. So, I would say most likely, almost certainly, you have a very, very solid case. But of course, you have to stop working, or get to the point where you're going to say, okay, I'm going to stop working on, May 1, April 1, June 1, something like that, and then you can file. But yeah, I think once you file after you stop working, I think you'd have a pretty solid case. Essay, should my back restrictions not have 5-hour driving? I don't think it's even relevant, and I think I want to keep on working. How can I move 1,100 miles with my car without jeopardy to my case? Yeah, I mean, I see your point. I mean, I think that, if you have a 5-hour restriction on driving, that is not especially limiting. I mean, that's a long time to be driving, 5 hours. I mean, most of us without back issues, I mean, I would not drive 5 hours straight without taking a break. I've got, some degenerative disc disease, like, most people, get over time. But yeah, that's not much of a limitation. And it'd be relevant to a judge, but, I don't think that that's a limitation that's going to help your case. In fact, it would probably hurt your case. So I think, that's not a limitation I would really want to see, to take into a disability case, because it's really not much of a limitation at all. Melissa Herrera. Pleased to interact with 53 want to apply for DAC benefits off your deceased father's record. The medical records before I was 22 don't exist anymore. I was receiving SSI from 28 to 36, or from, and then what other evidence I used to prove? Yeah, I mean, the only thing I would tell you would be you were on SSI for all those years, from 28 to 36. So there's got to be a file someplace explaining why you're on SSI. It is a problem not to have those records. Now, whether a doctor today could look at you and say, these problems are, consistent with problems that would have existed when you were, 22, 23 years old. Um, I don't know. I mean, I think the fact that you were on benefits is evidence. The question is what's in that file. But yeah, without the records, it could be difficult. Not impossible, but difficult. But I would try to see what they've already got in your file. And you might even need to, and I've never done this for this purpose, file a Freedom of Information Act to see if you can get it, maybe in a storage place someplace. I mean, I've filed some Freedom of Information Act requests before, not for something like this, but that may be how you get it. And I would look closely at the medical record you do have, whatever you can get from Social Security to explain why you were deemed disabled back in those days. And of course, you were on disability, you said, on SSI from 28 to 36. That's not 22 to 36. So, there's that 6 year gap right there. So, yeah, it's going to be an uphill battle. Not impossible, but an uphill battle. Um, Oscar Vega, 58 and some months. Have osteoarthritis, anxiety, depression, PTSD. Looking for an SSD attorney. Did call the office 2 weeks. Nobody called me back. Again, I make sure we respond to everybody. You know, uh, Again, I'll make a note of that. I will take a look and I'll make sure that I get back to you. Your name does ring a bell. Let me just put this here. Um, so I'll see what happened to that. Yeah, I will. I will follow up. In fact, let me take a quick look. If I can do it quickly, because I remember your name. I just remember that. Okay. March 7th, you called, which is 5 days ago. So not 2 weeks ago. Okay, so I think let's maybe it's the different person. I don't know. I had um, all right. Well, anyway, I'm not going to go. I'm going to sit here and go through what I'm having. But I had you, according to what I showed here, if it's the same person, you were older. You were not fit. I had it that you were 68. So maybe there was a typo there because I think the email that was sent to you basically said um, that you were at retirement age and that you're not going to be able to get disability. So maybe there was a mistake there. I'll follow up with you tomorrow. But I do see that I did send, or my staff sent an email to you a couple of days ago, but I will follow up with that, Oscar. Okay. Um, if approved for SSI, Melissa says, well, my benefits were reduced because I'm living in a condo owned by my third-party trust. That is a deeming issue for SSI. Of course, DAC benefits are disability, not SSI. So if you're approved for SSI, um, I don't know, honestly. I'm not sure how it would work with the trust. I'm thinking that they probably would, but I don't know. That's really more of a question that you need to look at as far as what are called deeming issues. Um, and Greg Brinkley, who I've been had on it before, might be a better resource than me. Greg at I think it's gregbrinkley.org. Let me just double check that. Would probably be able to answer that question for me. Yes, Greg Brinkley, G-R-E-G, at gregbrinkley.org would be the person to ask that question. I don't know. Susie B. Your lives are always helpful. Thank you, Susie. I appreciate that. Recently approved at 60, no CDR, noted letter. For 60, Susie, it's not likely at all because you're so close to retirement age. You're not on their watch list. I just don't. I really don't think it's likely at all. Really don't. I think it's just much more for people in their 30s and 40s. So I think you're not going to be. I would not be too concerned about that. But thank you for the kind words. All right, Jim is 61 on SSDI for 6 years, looking to work $400 or $500 a month, or is losing a bit. No, you're below the trial work period amount, which is like $1,100, and you're well below SGA, which is 1620. $500 a month is not going to, at 61, not a problem at all. Go for it. John Lee. Hello, John. Can grads be applied, grids maybe, at the initial application stage? Yes. In fact, when I do an initial application and somebody is over 50 or over 55 and the grids apply, I will say in the application in a remark, please, evaluate under the grid rules. And I will cite the grid. So absolutely, absolutely. You can do it at any point, initial recon or hearing. Christina says hello, everybody. Hello, Christina. Jeff Brown says, I applied for SSDI, was denied back in 2017, have no earnings for 18, 19, and 20, been back to work since 21 to present. If I file again in the next few months, how does your date last insured play out? I would get your My Social Security statement. It will tell you, there will be two things to look at there. One is it'll be part of it. It'll say if you filed now, you have enough credits for disability. The other thing you can do is look at the earnings over the last 10 years and manually figure it out. You can, if you type in, earnings to get, in fact, I'll give you the link where you can go to see this. I'm going to give you here's the link here, quarter of coverage. Okay, so let me just share the screen. It might be an easier thing to do. Okay, so what I'm showing you here is the quarters of coverage table. And so you'll see in 2025, you needed $1,810 to get a quarter of coverage. So 1,810 times 4 is $7,240. So when you have $7,240, doesn't matter, you earn it all the first day of January, you have all 4 quarters. So if you started back to work in 2021 and you've got 4 quarters in 21, 4 in 22, 23, 24. So you might have your 5 years already at this point. And if you look back at the 10 years, back to 2017, you may be okay. But you could literally put on a piece of paper your earnings for all these years, let's say starting in 2017 on, then multiply the figures in this table by 4 and see, do you have 4 quarters or 3 quarters? How many quarters? And see, does it add up to 20 quarters in the last, or 20 credits in the last 40 quarters? And that's how you know. But the My Social Security statement would probably be an easier way to do it. It'll tell you directly. And that doesn't tell you as clearly as it ought to, but you can do the calculations pretty easy. That's what I do when I'm doing a calculation. All right, let's stop the sharing there. And John says, who and how are exertion levels determined with the grid rules, sedentary, light, medium? That's a great question, John. It's a very, very good question. People don't really ask it. That's an excellent question. That is something that's going to be determined typically by a judge or by Social Security decision maker, but it would be something that a doctor would be able to comment on. So if your doctor gives you a 10-pound lifting restriction, let's say, that by definition is going to put you in the light category, because light is 10 pounds frequently, 20 pounds occasionally. If you have a 4-hour standing and walking restriction, that's going to put you into light as well. So, it's a decision that somebody's got to make. If you have a doctor who's addressed it specifically, that's even better. But you can certainly argue that the medical evidence clearly suggests that my maximum exertional capacity would be a reduced range of light work or a reduced range of sedentary, something like that. And, somebody's got to make a decision, but you can certainly argue it. Obviously, if you can point to a medical report. You can say, I have a medical report showing I have two herniated discs, one at L4-5, one at L5-S1, with impingement on the S1 nerve root. Um, and my symptoms of radiating pain into the left leg. That it's certainly very reasonable to conclude that my lifting capacity would be no no more than 10 pounds or no more than 20 pounds, and then standing and walking, you know, are going to be less than 3 to 4 hours a day. I will testify to that, or you have a statement to that effect. But if your doctor would say it, that's even better. But it's a very good question. But it's sort of a combination of either a decision made by someone at Social Security or your doctor states it clearly in the record. Obviously, when the doctor puts it in the record, that's not inherently binding on Social Security, but it's going to be very, very powerful evidence. At some point, someone in Social Security has got to make that decision. But that's how it's made. But it's because technically the term residual functional capacity, which is really what the grid rules talk about, that your residual functional capacity is limited to light or sedentary. Residual functional capacity, or RFC, is a legal term. It is a term defined by the law, based on what somebody in authority, a judge, would conclude. So it's not a medical determination, it's a legal determination. So, as an advocate or as your advocate for yourself, you want to make the argument that my RFC is a reduced level of light work or a reduced range of sedentary or light or whatever you decide it may be, and argue why the evidence supports that. That's what I do at hearings or in a brief, as I say, this is what I think the RFC ought to be found to be. Okay. Two dog mom. I'm a one dog dad. You're a two dog mom. On SSDI compassionate allowance since 60, now 62, I'll get a CDR. I would think almost certainly not. If you're in compassionate allowance, says it's a very serious listing level case, you're not going to be in the range of people they're going to be looking at unless you're working, unless your earnings that are showing up under your Social Security number. I think the answer is almost certainly no. Escadals. What if the vocational expert finds I cannot do full-time work or previous work at full-time? Then you win. Because the vocational witness, well, assuming the judge accepts the vocational witness testimony, but, to be found not disabled, the Social Security's got to prove assuming that, well, let's start with, and most of the time in hearings, you get to the step 5, where it's any work at all. If you cannot do past work, then the burden shifts to Social Security that you could do something else. And so if you can't do any full-time work, then you are disabled. Now, let me clarify something. Judges in testimony, in hearing testimony, will ask multiple questions of the vocational witness. One of those questions may be, Mr. Vocational Witness, I want you to assume X, Y, and Z, no ladders, ropes, and scaffolds, limited to, light work, no climbing ladders, ropes, and scaffold, no working hazardous equipment, moving machinery. This person would likely be off task 15% of the day or miss 2 days of work per month. Could this person return to past work or any other work? No. But that may be one question the judge asks. The judge might ask 4 other questions. One of those other questions might be the hypothetical, the RFC conclusion the judge reaches in your case. So just because one of the questions to the VE got no jobs doesn't mean you win. It means that's one possibility. Hopefully that's the one the judge adopts, but it does not mean that that judge has to take that one, because it's going to depend on the question. And I remember I had a case that I'm working on an appeal now with co-counsel, that my client said to me, well, the VE said no jobs, and clearly said could not go to past work, no jobs. I listened to the hearing tape. I didn't do the original hearing. The VE asked 4 questions, or the judge asked 4 questions of the VE. One of those was yes, no jobs was the answer. The other 3, there were jobs. So, you got to think about what actually happened at the hearing. Were there some questions that yielded the response of, yes, there are jobs that I could identify? Christina says, please do not hesitate or forget to like, share the video. Yes, thank you very much. I really would appreciate that. And I've got in here, by the way, if you are so inclined and would write me a nice review for these live streams and the videos, that would be really, really appreciated. Very awesome. You can do it at Google. You can go to Avo. You can do it at LinkedIn. You can do it at Facebook. But again, there's a link there. And so I would really appreciate it. Thank you. Input. Okay, I'm not sure what that means. Did I say, maybe I said input? It's input. Okay. Then I stand corrected if that's what I said. Okay. Stargirl. Is it possible to recover deleted message from T-Mobile? My employer showing was fired due to illness, but it's my claim or any attorney. I don't know. That's a good question. I do not know whether T-Mobile or Verizon or these other people save messages. You'd have to get a subpoena from them. I do not know the answer to that. Honestly, do not know. Interesting question, but I don't know. Okay. Let's see here. Christina says, please. Yes, thank you, Christina. Christina is an unpaid volunteer for my live stream. I really appreciate it. Blues City, 30 miles from Memphis. Okay, I figured someplace in Tennessee. Oh, you're in Mississippi. Okay. Okay, great. Thank you. I appreciate the recommendation. You're 16, 19 months later. I'm still in the initial. Way too long. Way too long. You should not be waiting 19 months. You need to contact, let's see who the senators are from Mississippi, and ask for a congressional increase. Senator Wicker or Senator Hyde Smith. I want you, Blue City, to get online tomorrow and contact either Wicker or Hyde Smith. And there's a form on their website that says, need help with a federal agency. And you say, I filed for disability. I've been waiting for almost 2 years, and this is way too long. It's causing terrible hardship. Will you please initiate a congressional inquiry? And that will get things moving. This just shows you how crazy how long this can get. This is crazy. After you get approved, Blue Z says, and you have kids under 18, which they call them auxiliaries, qualified, do you need to open up a separate account, or does it all go into the one account monthly? I do not know. I think it goes into one account. Now, you could theoretically set up sub-accounts for each of the auxiliaries. In fact, I would probably tell you to do that. But I think it all goes into one account, if I'm not mistaken. These are interesting questions. I never thought of that. I mean, it's just because once I get somebody on benefits, I'm not really involved in bank account stuff. I mean, other than to, encourage people to do direct deposit, but I don't know how the payments actually come. Robert says, if your case was remanded is the term, by the appeals councils, increase your odds of winning it all. You said remanded here. Okay, you caught your error there. I get this question a lot, and my answer to this would be as follows. I think that some judges, when they get a remand, they recognize that it's a bit of a slap on the wrist, that they've been, reversed, and they don't particularly like getting reversed over and over. When they come up for review, I would think that the number of remands would be a factor there. That being so, I would say a certain percentage of judges pick up on the message. Of course, it depends on what the remand order says, but half of them are going to say, if the appeals council went to the trouble of accepting this case and remanding it, they're telling me that I need to approve it. There are some judges who have big egos, and they're like, I don't give a flying blank about what the appeals council says. I'm going to do what I want to do. It just depends on the judge. I would say, by and large, it's probably it probably will work to your benefit. I don't see judges taking it on, they don't hold it against you for appealing. They don't hold it against your attorney for appealing. At least to my knowledge. I think though that and I'm going to have a judge on here. I need to call him. I know he was out of this country for a little while, and I'll get him on. That's a good question to ask him, is if he got a remand order, he'll probably say, I'm going to look at the facts as they are. But I can't believe that a judge getting a remanded case would not be at least something to look at, saying, maybe I need to give this one a whole another look. That's my take at least. Okay, so Deb is asking Two Dog Mom. She was asking about Two Dog Mom was asking about CDR, and does it say medical improvement expected or not expected? And again, if you're in your late 50s, early 60s, it's just not going to happen. I don't think. Jack Lowe, good question. With Elon looking at Social Security, will more people get surprise reviews? I'm going to answer yes. I think that is a low-hanging fruit. I think it's an easy thing to do, to go after people who are on benefits, to review them, because again, they're not going to have lawyers generally to fight it. I think we're going to see more of that. I said that earlier. I think that's absolutely what's going to happen. That's the low-hanging fruit. There's a medical questionnaire from my doctor guarantee my disability case, asks A. There are no guarantees in Social Security. It will help. Now, is this your family doctor? Is it a specialist? Excuse me, who is it? I should probably start drinking carbonated water here. But anyway, no guarantees. I mean, it certainly will help. It's better than not having it. But it is not a guarantee. Now, back in the day, 5 or 6 years ago, they had something called the treating source rule, which basically said an opinion from a treating source was to be given controlling weight. In their wisdom, Social Security got rid of that, which means that a Social Security judge can take the opinion of a non-examining doctor or a consultative doctor who saw you for 30 minutes and completely discount 5 years worth of treatment from a specialist. Does it happen very often? No. But theoretically it could. So I would tell you it's not a guarantee, but it's better to have it in your corner than not. Okay, so we're talking about reviews, so I'll just leave that here. Okay, SSI, I'm interviewing told on work credits for SSD. I'm in step 3. Okay, well, good. If you have the credits, then, and maybe you got presumptive SSI. I've got a few people like that. I think that generally speaking, when you apply for SSDI, you're looking at 8 to 12 months. At recon, maybe 8 to 10 months, 11 months, and at hearings, 5 to 7 months. But I would say that the general time frame I deal with, I'm trying cases now that people applied 2.5 to 3 years ago. So if that tells you anything. What is the latest, asked Devi, about this getting out SSDI checks and direct deposits? Okay. At this point now, I realize that former Commissioner O'Malley says he thinks there's going to be a disruption in payment. I do not think so. So I've not heard anything to suggest there's going to be a delay or disruption in payments. There are some people who think that it might happen because of the, personnel shortages or all the, things going on at Social Security. I'm not one of those. I think they're going to make sure the checks go out. 6 hours a day walking. Yeah, right. I mean, we're talking about somebody was asking about I think it was 5 hours driving, if that's what you're talking about. But, light work is defined as 6 hours standing and walking in the course of a day, up to 2 hours sitting. Yeah, you're on your feet all day long. That is a lot. Absolutely. Absolutely. In fact, I was going to do a video. Let's see what I had to say. Surprised by the definition. Yeah, the definition of light is standing and walking 6 hours a day, lifting 10 pounds frequently, 20 pounds on occasion. I was actually going to take my recycle bin and weigh it and just show people doing a video in my garage or my driveway what 20 pounds looks like. I mean, my recycle bin full of, plastics and paper and all that kind of stuff, it's 20 pounds. And, it's a lot of weight. It's not a small amount of weight. And, doing that all day long, or for Social Security purposes, a third of the day, say 2 hours a day, 2.5 hours a day, that is hard. That's physical work, not easy. So yeah, I think people sometimes overestimate their capacity to lift that. All right, John Myers, been shot down 4 times for major depression, but gave up all the paperwork, just can't do it anymore. Yeah, I mean, I hear this. People get really frustrated. Not you didn't say if you've gone to a hearing yet, or just getting shot down administratively. If you've not gone to a hearing, then I would say you probably need to go through that. Look, in my opinion, this is just me. To win a depression case, you need to have evidence of significant severity, and that would be inpatient hospitalizations, suicide attempts, as difficult as those are, failed medication trials. Doctors keep giving you more medications, different medications, years of ongoing treatment. That's the level you got to be at. It can't be mild depression, moderate depression. It's got to be severe that, makes it hard for you to do activities of daily living. So that's the level of evidence you need, in my opinion, to win a depression case. Shelby says, you were a disability attorney and you left, written hundreds of opinions for disability cases, worked with plenty of judges. Do you want to chat? So I'm absolutely would love to chat with you. Just if you will send me an email, just SSD. Have we not corresponded? I could swear. Now you got me. I got to go look. I could swear that we've corresponded a little bit, but I would absolutely love to talk to you because um, Um, okay. Well, anyway, email me ssdanswers123 at gmail. That would be great. I would love to talk to you because the more insight I can get from people who've, uh, worked for Social Security or who have worked with judges, absolutely. Maybe we can have you on as a guest. That would be great. That would be great. But then thank you for that. Dennis Santos, do lawyers get a portion of auxiliary benefits after you're approved? Um, Generally speaking, it's all part of the same case. So the legal fees in disability cases, most of the contracts that Social Security provides to us, the 1693 says anybody who's associated with your case, because the auxiliaries are getting benefits because you were found disabled. It's not about who filed the application. The lawyer was responsible for getting you approved. Therefore, any beneficiaries that go along with you are part of the fee. Now, realize there's a $9,200 cap on it, so it's not $9,200 for you and for your auxiliaries and each one of them. It's $9,200 total for everybody. So yes, the lawyer will get paid a fee for benefits that arise from winning your case, whether the benefits go to you or your auxiliary. Okay. If you have a medical, this is about the medical marijuana. And this is very good advice from Starglow. If you have a medical marijuana card, make sure it's active. Do follow-ups with your doctor. Pain management doctors check for it in urine. Then ask for the card and check, make sure it's not expired. Very, very good point. We do not have, I don't believe, medical marijuana in Georgia. I do have one friend who gets medical marijuana like oil or tincture or something for irritable bowel. Um, but we don't have medical marijuana like dispensaries like they have in Los Angeles or Las Vegas, things like that. Um, so, I'm not familiar with how those cards work, but I think Stargirl's advice is very, very good. And that is, medical marijuana should not be seen as a way to get marijuana to get high. This is for medical purposes. And if you're using it for that purpose, that's what you should be using it for. I'm not making judgment. People can do what they want to do in their spare time. But I'm saying for Social Security, if a judge got the sense that you were using your medical marijuana to buy pot to get high, that's going to work against you. You got to keep it to the purpose for which it was intended. Um, Melissa Herrera, would SSA pay for an adult autism assessment, neuropsych exam? Sometimes they'll do neuropsych exams, not that often. I would not assume that they will. I would probably tell you that you need to get your own neuropsych evaluation. Do not rely on Social Security to do it. They are, and I think especially now, they're really cutting back on the budgets for these outside exams with specialists. In fact, I've seen fewer exams just for regular psych exam and regular medical exams. So I would not assume or rely on them to do a neuropsych exam, which you probably, based on what you're telling me here, you probably do need. Um, and how long does it take? Again, this is all part of that 8 months to a year. Um, Integrity means all. That's a very good. I like that. That's a very good saying. Very true. Would people who have been on SSRIs, serotonin up, what is it? Uh, I forget what the abbreviation stands for, but it's the intake inhibitors, I believe, right? The antidepressants for around 20 years for a stronger case. It does show, obviously a history of an ongoing mental health problem. So if you're on medication for that long period of time, the question is, are the medications effectiveness wearing off such that you're symptomatic and that they're looking for something else or increasing the dosage? But it does show a long-term problem. So that is part of the puzzle. But the bigger part is, are you functional? In other words, if you're taking a medication, whether it's antidepressants or breathing treatment or cardiac treatment or pain medications and you're able to function at a job, you're not disabled. So the real question here is, you may have been on for 20 years, but if it's working and it's allowing you to work, then you would not be disabled. The question is, and this is not uncommon for antidepressants, the effectiveness begins to wear off at some point just because your body gets used to it. So that may be what's going on here. But yeah, the 20 years does show a long-term problem, which I think is very, very relevant. Um, How many breaks would I need to make a move with 1,100 miles? Also, with 3 to 5 hours sitting be detrimental? Yeah, I mean, I think that, 3 to 5 hours sitting, if a judge is looking at that, judge is saying to him or herself, well, if the person can sit 3 to 5 hours, that sounds like what you might have to do in a job. Um, you know, I can't give you a number to say, well, how many breaks would you need? I will tell you that in cases where this comes up, if my client is saying every 20 to 30 minutes, I'm having to stop and take a 10-minute break, that is saying to the judge that even in a sit down job, you're taking a break every 30 to 40 minutes. That is excessive. So I'm not saying that's what you should say because I don't want to put words in your mouth, but that's the level of impairment that I think that to be relevant here, what you would need to show. Um, what breaks added in to make 3 hour. Again, it's not about what I consider acceptable. I'm just saying is that, you want to paint a picture that if you are going to be sitting for 3 to 5 hours, that, like if you're in an office setting and you've got to stand up and move around away from the work site, that's a problem. If you just simply stand up, and you can continue working, that's not a problem. So it's all part of the big picture and the narrative you are weaving. And that is that, you're sitting. And the other question is, if you're moving and you're doing this 3 to 5 hour trip one time, and then you're in a week, next week you're in bed, that doesn't really tell us very much about your capacity, right? So I think it's just going to all come down to, is this a one-time thing? What kind of accommodations did you have? Did you stop every 45 minutes to an hour, every 30 minutes, every hour and a half? I would say certainly if you're stopping at once an hour, that's also fairly significant. And then if I'm a judge and your an essay is coming up to testify in front of me, and I say, well, what's the largest car trip you've taken? Well, I had to move 1,100 miles, and I couldn't afford to hire a moving company, so I did it myself. And I drove, and for an hour, and had to stop and walk around for 10 minutes, and got back in and did another hour, and got out, walked around for 10 minutes. I finally made it, and I was in bed for the next week. That's going to tell me that this person's, capacity is not enough where that doesn't tell me they could sit for 3 or 4 hours at a job. But if they said, well, I drove 5 or 6 hours, and was able to do that, and nothing is said about the repercussions the next day or two, then I'm going to say, well, that sort of says to me this person has the capacity to sit for 3 to 5 hours, which is not going to really help their disability case, if that makes any sense of how I'm explaining it. Um, uh, I'm not sure who's asking. I am not taking, personally, do not take antidepressants. I think, and there's not, and I shouldn't be facetious about it. But no, I'm not taking antidepressants. I've never taken them. I know people who have, obviously many of my clients and so forth. But I would tell you that, any kind of medication has side effects. And antidepressants certainly do have side effects. Fatigue could be some, there could be other things. And I think, if you are taking them, you look at WebMD and get a sense of what the known side effects would be. Um, and again, the question really is, are they effective for you? But personally, no, I'm not, and I have not ever taken them. Um, let's see. Okay, so Deb says she's been on disability for 15 years. She's 61, had never had a CDR, and that could simply be because her case, she had multiple medical issues, and she was obviously tagged as, not being one that they need to review. Silver Monster has been here before. Just got denied an initial. I think it will go to, but if you got denied initial, next step is recon. Probably not going to get approved. You'll go to a hearing. The judge could move it to your 50th. That is very possible. I just had this happen to me. Did not make me very happy because I'm not getting paid a dime. Had this case for 2.5 years, won at the hearing. The judge just moved the onset date up. And I think this is, some of the messaging coming from higher ups is to change the onset date to reduce the outflow. So yeah, would not make me very happy, but that very well could happen. What does it mean when you review? That's kind of generic. It doesn't tell you anything. It doesn't tell you what, if they're looking at it, reviewing it in a year, they're looking at reviewing it in, 3 to 5 years, 5 to 7 years. Being 56 says to me that you're probably not going to get reviewed much, maybe once, if at all. I sound like a broken record. I don't mean to give assurances because I can't, because people have told me that they're in their 50s, late 50s, and get it reviewed. But the low hanging fruit here are people who are in their 30s and 40s, let's say with mental health issues, who, that's who they're going to review. The people who are close to retirement age, by the time you appeal it and you appeal it again, you may be close to retirement age. It's all kind of moot. So it's just, I just don't see that there's a lot of value in going after people who are 58, 59 years old, because you can still have the grid rules that apply. They're older. There's an inherent bias in Social Security in favor of people who are over age 55. That's just not the easy people to go after. Mike, the original gamer, how long does it take to get scheduled for an ALJ in Texas? I mean, I'm getting my Texas cases scheduled, relatively quickly. In fact, like I said, I had a call or email this week from a hearing office staff person in Houston, who was it Houston or Dallas? I can't remember if Houston or Dallas. And now I got to thinking about it. I got to look, because I just literally emailed with her today. Anyway, well, I can't find it off the top of my head, but basically what we did was she found a couple of spots in there. I'm getting a hearing like, within a few weeks of requesting one. So you could waive notice and get a faster hearing. Now, again, that's something you want to do in conjunction with your attorney, but theoretically you could waive notice going quickly. But I would say the backlog is not at the hearing level right now. The backlog is at initial and recon. So I would stick with my 5 to 7 months, which is, about the quickest they can do it with giving everyone proper notice. Yeah, I agree with what Deb says. By the time they do review, it's moot anyway. Okay, Jeff says you got 40 credits. Well, again, 40 credits is talking about retirement. Disability is something different. Look at your My Social Security statement. You'll see you have enough credits for retirement. You got 40 credits. Do you have the 20 credits in the last 40 quarters you need for Social Security disability? Two different things. You could have enough for retirement, but not enough for disability. Debbie, this is responding to my comment about what Social Security is designed to do. You're absolutely right. There are no more pensions for the most part. The trust fund needs to be reformed. Can't stop taking the permanently disabled. We aren't animals or cold-blooded narcissists like Trump. So again, I think that, there needs to be some change here. What form that will take has got to be negotiated. And I think that, I would say this, that members of Congress from both parties, do not know what it's like to struggle to live paycheck to paycheck to not know where the next meal is coming from. Um, you know, that's just not the world they inhabit. They have first class health insurance. They get a salary for life. They have people giving them money. They don't live in the same world we do. And if you look at some of these people that are getting paid 180 or $190,000 a year, and they're now multimillionaires, 50, 60, $70 million, where's that coming from? They don't live in the same world. I even say this about some judges, and not so much anymore, but at one point, one of my colleagues made the comment, another attorney said, well, if you're a judge, most of the judges are going to be in their 40s, 50s, 60s. Many of them have already had a career, either through the federal government or as private attorneys, and they've got good insurance. And so I remember one friend of mine made a comment about a judge who had denied a case, and he's like, well, this judge, he had back surgery, and so he was very fond. He's retired, long since retired, but he was very fond of saying to people, well, I had back surgery and I'm able to go back to work. Yeah, but you had back surgery with a really good doctor. Point one. And that is that, there are some good doctors who do back surgery and some not so good ones. You get a really, you go to an Emory doctor, here in Atlanta, you're going to get a really good result. You go to a small hospital outside of Atlanta, you may not get as good of a result. So you go into a really good doctor if you're a judge. Number two, you've got really good insurance. You don't have to worry about, leaving the hospital early. You're not going to get kicked out. The insurance is not going to tell the doctor they can't do this procedure. They can't prescribe this medication. Number three is your insurance probably covers rehabilitation. Many insurances do not. So there can be a big difference between members of Congress, or even judges who have, or even lawyers for that matter. I'll put lawyers in that same boat. If you don't have this, if you're not working on a very, very, limited HMO type of plan, okay, you're going to have a different experience and different result in surgery and medical treatment than someone who has a better type of plan or has the money to pay for it if they want to come out of pocket. That's just the reality of it. So I think that, that's part of this too. I think that it's not just the president. It's not just, one particular judge. It's just that, the people in Congress are not, they're not destitute. They're usually pretty wealthy and getting wealthier. So they don't really understand what it's like to live, in a more difficult financial circumstance. I'll rant over. Okay. Kurel Katana. Unbelievable. Okay. I trust. Please take care. Okay. Okay. Um, I hear you. I know. I think if you are, I think you are. You just got your recon denial, and I know you're pretty upset. We'll talk about it. If you are, I think you are, then we will talk about it. But recon, I would tell you not to take personally because they don't approve too many people at recon. But yeah, it's frustrating. It's frustrating. Let's see what we got here. The cap must be removed. I think you're talking about the earnings cap for payment to the Social Security system. Again, it's political. It's very political. So whether that will happen, we don't know. North Carolina can use disability for a third degree burn, but waiting for 3 years. Okay, so just to clarify, first of all, Social Security is national. It's not just North Carolina. The judges are going to be in North Carolina, but it's a national program, so the definition is national. The third degree burn does not tell me whether you're disabled or not. What does that mean in terms of your functioning? Are you in pain? Do you have problems lifting? Do you have PTSD? What are the practical issues that would impact you from working because of that third degree burn? Just having a third degree burn, like having a herniated disc or having a kidney disease or having PTSD or depression, those are diagnoses. You don't win with the diagnosis. You win because of the effect it has on you. So that would be the question. Okay, so Jack was asking about the frequency of reviews. A 7-year review basically means no review. So they're basically 1-year reviews, almost certainly going to happen. 3 to 5 years, possibly, probably. 5 to 7 years ain't going to happen. That's generally speaking there. All right, Melissa was asking about the DAC benefit. It's not been submitted yet. Yeah, go ahead and get it in. You've had your psychological CE. No, I think if you have it in, go ahead and get it in. I mean, even if it's late, get it in. T-Mobile can talk to you about retrieving deleted messages. Very possible. I don't know. I had T-Mobile for a little while. They were fine. My wife didn't like it. She felt that we didn't get coverage at home, so we moved. Actually, we were on Verizon for many years, which I liked. I think Verizon had great coverage, but then the prices kept going up, and the customer service was not as good as I liked. So we went to T-Mobile. Again, some people in my family are not thrilled with it, so then we moved to Comcast, which is on the Verizon network, and it's really been fine. I get a good signal at my house and any place else, so it works fine. I think at this point, most of the major networks are all pretty good. How would it work? My 15-year-old daughter and I are eligible for SSI. If you're asking about the deeming rules, again, that's probably a question that I would ask Greg Brinkley. I don't know enough about the deeming rules to really say. Okay, T-Mobile said they need to get a subpoena. You would ask the Social Security judge to issue a subpoena for that. Subpoenas in Social Security cases are a little strange, so there's a real question in my mind as to whether they have legal, that they can be enforced because they're not judicial, they're administrative. Now, whether T-Mobile, if they get something that says subpoena on it, would respond to it, I don't know. But that's how you would do it. You have to ask the judge for that. Jenny Joe, how are you doing? And Jenny Joe had a birthday a couple of days ago, so let's all wish her a happy birthday. Good to see you. And T-Dog will be 64. What are your chances of CDR? Almost none. They're not going to do it. Okay, let's see. If they include one with less strength than older women, we're talking about the definitions of light, sedentary, and so forth. And so what he's getting at is, or she, I don't know if you're he or she, that the definition of light work is standing and walking 6 out of 8 hours, lifting 10 pounds frequently 20 pounds on occasion. And so his point is that an older woman, that level of physical exertion is not the same as it would be for a 25-year-old man. So why do they have the same definition of light for everybody, no matter how old you are, or if you're a 100-pound woman versus a 250-pound man? That's a very good point. That's an excellent point. And arguably, you could make the argument that if you look at like the pulmonary listings, I'll just tell you, for example, they differentiate between men and women, and I believe they differentiate between men and women. They certainly differentiate based on your height and your weight. So yeah, I think that's a pretty good argument that, a light RFC, for a 100-pound woman, really should be less than what it would be for a 250-pound man. That's probably something that the Social Security Administration and or Congress would have to do, but that's actually a very, very good point. In fact, what my thought on that would be, in a vocational, testimony, if I'm cross-examining a vocational witness, that might be a question I ask a VE, is that, the exertional requirements, are you looking at them the same way if it's a 90-pound, 58-year-old woman as it would be a 25-year-old, 250-pound man? Because I think it's very different, and that's a very good point. But right now, it's all the same. It's all the same. John says he did go to a hearing. Maybe John was the person who you said that you were getting really frustrated with the whole process and you got turned down. Again, just because I think mental health cases are just inherently difficult to win, unfortunately. Yeah, I think that's your point here. Integrity is a good point that most women, again, I wouldn't say, maybe it's hard to say most, but many women could not do the same level of physical labor as men, especially older ones. I think that's a fair statement. But yeah, you make a very good point. And John says you were hospitalized twice. Um, you had a bad attorney. You could have, you know what, you could have had a really bad judge. Look, I got two cases coming up in the next month with the two least approved, the judges with the two worst approval ratings in the whole country. Two of them in one 2 week span. I got two of the worst judges you could possibly get. It's just, bad luck. Sometimes it happens. I'm going to try my best with both of them, pre-hearing briefs, the whole 9 yards. But what are you going to do? What are you going to do? One of these judges, actually, there was an article in the Washington Post about a ridiculous decision that this judge denied. But, what are you going to do? That's the Social Security, has some of these judges there. John Zima, stopped working a full time about a year ago because of epilepsy. Have your 40 credits again. 40 credits says retirement, not disability, but you're working up to a year ago, so you're probably okay with that. Tried part-time work, but couldn't sustain it. Part-time work earnings hurt. No, they help you because it shows you're motivated to try to work and that you actually did try to work. So I think that actually works in your favor. And I think it shows that you're motivated to try to work. Yeah, I think that's all very helpful. John Myers, that you're welcome, John. I hope that things go well for you. I'm sorry the system did not do for you what it was really designed to do. KN is a hearing tomorrow. 37 fibro chronic back pain. Have an advocate. My doctor agrees. I think the 37 is tough and the fibro is tough. Those are hard things to get past. If you've got fibro and you've got really strong medical support and, you've got chronic pain and there's some objective evidence for that, you've got a chance. And of course, let us know. I just think that anybody at 37 right now is a real uphill battle. And fibro, because it's somewhat subjective, uphill battle. So I hope you have good result. It would be, in my opinion, probably an uphill battle, but I hope I'm wrong, and hopefully you get approved. Let us know, certainly. John says you're on meds and got a DUI. Yeah, I absolutely understand that. DJ Kenny applied 7 months ago, waiting review. My date disability was in 2020. Have an attorney. My insurance date was up. So your date last insured, January of 23. Tried a job. Couldn't sit instead 45 minutes. So you have what is called an unsuccessful work attempt, which I think does help you. You're alleging an onset date back in 2020. Now realize you applied 7 months ago. So let's assume that you applied in September of 24. All right. If you're found disabled in 2020, you get paid only from September of 23. You only get paid 1 year prior to your application. I'm assuming no prior applications. So what you might look at doing is amending your onset date to, let's say, if your onset date, if you applied in September of 24, and your onset date was, I'm just spitballing this, well, you have to say January of 23. So your onset date needs to be before January of 23. You can make it, if it's January 31 of 23, you could make it January 30th of 23. Is that right? Let's see. Yeah, because you're not going to get paid. The earliest you could get paid would be in if you, let's say you September of 23, you will get paid 1 year prior to application, no matter when you were found disabled. So yeah, you may want to look at changing your onset date to right before your date last insured. That's less for you to have to prove. Now again, maybe the evidence does support an earlier onset date. It's not going to put more money in your pocket. You just want to make sure that your onset date, when all is said and done, is before your date last insured. I probably screwed up that explanation, but the big picture is that if you, let's say in your case, you got approved as of a disability began in 2020, the earliest they're going to pay you for would be 1 year prior to application, which if we're talking September of 24 means September of 23. You add 5 months to that, then you're in like say in February or whatever of 23, but you got to be in January of 23 to meet your date last insured. So I think if you made your onset date the day before your date last insured, you would max out your money, and it might make your case easier to process. Just an idea. Do the VEs always go above the the ALJs always go by what the VE says. Not always. I would say that they use the VEs to help them translate medical findings into vocational, limitations. So the judge uses the VE as a tool to help arrive at an RFC. I've had judges every once in a while just disregard a VE saying the VE didn't know what they were talking about. That's pretty rare. So I would tell you that the judge will almost always rely on the VE testimony. DJ Kinney has fibroscoliosis, IBS, POTS, cervical issues. I would tell you, DJ Kenny, that the IBS is going to be a stronger issue. The POTS, which is the where you get faint of your head gets the blood doesn't go to your head, so you feel faint when you stand up. The cervical issues, those are more objective. Those are going to be stronger, in my opinion, than the fibro. If you can do it. But because again, if you're DJ Kenny, if you are Kenny as in Kenneth male, fibro cases for men are hard. So I think you're better off in terms of choosing things that are more objective. Integrity says, how are meds and DUI related? They're not. I mean, when you said DUI, I kind of assumed you meant that you were under the influence, which could be drugs, it could be alcohol. If you say you quit meds because of a DUI, I assume there was a relationship there, but it doesn't have to be. What I read that to mean was that you were just trying to stay away from any mood altering, substance. So if I misunderstood that, I apologize. It wasn't trying to be, insulting or anything like that. But I think that that was my understanding, was you were just trying to get away from any kind of substance. Jenny Joe says, it's really surprising amount of weight. It's difficult to lift when you put it into perspective. Figured out when I discovered 5 pounds sugar in a gallon of milk. Yeah, a gallon of milk's 8 pounds. And like I said, I'm going to actually, I was thinking about this last night. I'm going to go in my driveway and just film myself lifting up things of various weights, and you can see what it means. I mean, 5 pounds is not that much. It just isn't. So, again, I mean, here's a garbage can, okay, small garbage can. I bet you if I filled this full of 2 or 3 phone books, it would be 10 pounds. And try to haul that around, it would be a lot. It would be a lot. I think that's not easy. Meds for depression, yeah, they don't get you DUI. I hear you. I wasn't implying that they did. So it took almost a year to get an answer in East Texas. Yeah, that's not surprising. Not surprising. Okay, serotonin reuptake and that's SSRI, that's what they are. Yeah, side effects of medications. I win a lot of cases of medication side effects, no question. Okay, what's in your blood was considered illegal. Okay, we eventually want to find, yeah, I hear it. They may say the people who increase dosage are aware of, even though would also like increased side effects. Absolutely, that's exactly the point. Is that if you're on mental health medications, that after a while they begin to kind of wear off the effect. They increase the dosage, but if that made you sleepy or hard to focus and concentrate, those side effects are going to be more magnified. Absolutely. Okay. How does a recent Baker Act? Now you got me wondering, what is a Baker Act? Let's see if I can look it up and I can tell you. Baker Act. It's a mental health, which allows emergency mental health. So it looks like it's a Florida law that allows for emergency mental health services and temporary detention for individuals who are mentally ill and pose a threat to themselves or others. So how does it improve chance of approve? So I think what you're asking is, if you were detained, put into a facility, incarcerated, whatever, because of a Baker Act determination, that is like a psych hospitalization. I think that works in your favor as of the time you had it. Now, again, if you're the person who's asking about disabled adult child, that may be part of the picture, but it obviously doesn't talk about what happened when you were 21 or 18 or whatever. But yeah, I think that if you have been had to be basically temporarily detained, that is evidence of a severe mental health issue. Absolutely. Um, okay. Okay. All right. I think I don't want to get confused, integrity, what you were meaning. So, if I misunderstood, I'm sorry. Your therapist Baker acted you a few months ago. So obviously you must have told your therapist something that made that person very concerned. And so again, that suggests something fairly um, severe. Amanda is deaf and hard of hearing, do not understand. You know what, Amanda, I think, you know, if I'm not mistaken, when YouTube puts this out, which we do as part of the YouTube channel, there'll be an ability to do a closed captioning um, of it so you can read what was going on. I know when we take pieces out of it, we'll run it through something called Descript, which is a little program that will caption it. So you'll see some captions on the replay. Um, okay. They think I'm eligible for retirement only 50. I'm too young for retirement. That's correct. Um, yeah, I think you got to be 62. That's correct. How do I feel or expect to happen applying at 60 for QDD? Yeah, I think it doesn't matter what age you are. If you have something that would qualify for QDD, a terminal illness, compassionate allowance, a severe listing level problem, doesn't matter how old you are. In fact, the age just helps you. But yeah, I think that is something that you got to ask for. But I think you should if you qualify for it. David Myers, how long you've seen decisions take past 90 is that sign one or the other? Uh, no, it is not a sign. In fact, I had an adjudicator tell me one time, or a decision writer tell me one time, that it took longer to write favorable decisions than unfavorable decisions. Um, Guy named Spencer Bishens. I need to get on here, but Spencer wrote a book about Social Security, and I interviewed him on the podcast, SSD Radio, if you want to go listen to it. Um, but I'm finding it's taking anywhere from about 3 weeks to 2 months. It just depends on the judge. There's no definitive answer on that, but it's taking longer than it used to. Amanda's not working at all. Haven't done work for a year, making food stamps, not getting employment again with Social Security. So I'm not sure how you're getting Social Security if you're 58, because you're not at retirement age, unless you're collecting on someone else's earnings record. I don't know. Jack says, thank you. Welcome, Jack. I appreciate it. Integrity means all. Says people who don't have real pain usually cannot relate to those who do. So with other things in life, part is human nature, part is like empathy. Um, Many times men cannot relate to women. As an example, how many little people seem to be able to understand when it goes through different things that they themselves um, have not undergone. Yeah, I think that there's a lot of truth to that. Again, I think you're referring to my comment about legislators or judges or even attorneys for that matter, doctors, people that, are, they're not struggling for the next meal. Let's call it that. Yeah, it can be hard to relate. I think you have to put yourself in other people's position. And look, any of us, you've heard the expression there, but for the grace of God go I. Any of us at any point could be in real trouble. I don't care how, unless you've got millions and millions of dollars, it could all go away in a second. You get scammed. I mean, these all hear about all these scams. People, they scam you out of your money. You make a bad investment. Who knows? Any number of things could happen. Um, so yeah, I think you have to always assume that you certainly should not think that if you are financially stable that you're a better person than anybody else. I think that's absurd. I think it's just could be some hard work, could be a little bit of luck, could be a number of things, but you treat everybody the same is ultimately. I think that's what you're getting at. And I completely agree. Um, NetStalker got approved at initial. Can I work and make less than 900 amount? Be by the review. You're 45. Again, the trial work period is over $1,000. I think it's 1,100 and something dollars. So you're below trial work. You're below SGA, obviously. Um, you know, I would say this, that Social Security wants to encourage people to work. So they've got the trial work program, they've got the ticket to work and all that kind of stuff. And so if they were to, you know, go after people who tried to work within those programs and word got out that you're being punished to try to work, guess what? Nobody's going to try to work, right? It's just not going to happen. Um, that being said, if you look at the short form CDR, it asks, do you have any earnings? And if you say yes, a live person looks at it. So the truth of the matter is, if you work at all, okay, there is a slightly higher risk of a review um, than it would be if you didn't work at all. Is it enough to make me tell somebody not to work? No. I would say if you can work and earn $900, the benefit to you, the financial benefit to you, and the peace of mind to you is worth the tiny extra risk. Because I think that, again, people earning $900 are not really their target. That being said, we're in a different era now. We have different actors now. So yeah, it could be something that somebody looks at, but I would still think if you were my client, I would tell you to go for it. I think it's worth doing. Um, yep. St. Louis Grand talks about some government officials have many dollars to their spouse's earnings. Nancy Pelosi, district appeal judges are wealthy because they were big partners before they became judges. Yeah, I think all that's very true. I think it's all very true. Um, you know, many times when someone becomes a judge, they're taking a pay cut. They've already, made their money doing big law if they're at a big law firm, and now they want to do something, a little different, intellectually challenging, maybe not quite as, dog eat dog as being a partner at a big law firm. They become a judge if they can get it. If they get, they have political connections, they get appointed or they run for judge. Um, and I will tell you, there's some judges I know that are personally very wealthy who are the nicest, most compassionate people you could ever hope to meet. There's some other judges who I don't know what their personal financial situation is, but they're not very nice people and they don't empathize. I think it's just a function of character. It's just a function of the person. Um, I don't think there's any, anyone who says, well, anybody who's a millionaire is evil. That's ridiculous because there are plenty of people, and I know a few of them, who are very, very wealthy, who are very charitable, give lots and lots of money away. Arthur Blank is one of the founders of Home Depot. Lives in Atlanta. And one of the most charitable people I've never met, Arthur Blank, but one of the most charitable people you could possibly ever hope to see. I mean, he's given millions and millions of dollars to different, built a children's hospital. I mean, Bernie Marcus, who just died. And by the way, the two of them were politically polar opposites. Marcus was a staunch Republican. Arthur Blank is a staunch Democrat. But Bernie Marcus, I mean, the Marcus Autism Center, the Georgia Aquarium. I mean, he, just funded all kind of things. So, it's the person. It's not their bank account. I mean, I can tell you from knowing people that have more money than could ever hope to have, are just some of the best people you could hope to see. And there are people that have a lot of money who aren't very nice. Steve Franklin, if you're an SSDI at 61 loses 60 from CDR for Medicare, I think so. I don't know. I mean, I don't deal enough with Medicare. I think that there is an extended period of time you get Medicare even after SSDI gets cut off, but I don't know. I would tell you this is something that Greg Brinkley might know. Greg at gregbrinkley.org, GregBrinkley. Check with Greg. He would probably know. I just do not know. I don't deal with Medicare issues per se. And Jeff Brown says, happy birthday to Jenny Joe. I was actually working on Jenny's file and I noticed, this is her birthday a couple of days ago. I'm like, okay. So I sent her an email, happy birthday. So I know she comes on every week here. So Stargirl says, if your boss ever sends you texts describing your illness affecting your work, they're firing you, don't delete them. Yeah, that's actually an ADA issue too, because not theoretically, under the Americans with Disability Act, if you are terminated because of an illness, you might have an ADA claim as well. Now, I'm not sure about the statute of limitations on that, but yeah, that would be smoking gun evidence. It could be, give you a very, very strong ADA case. So something to look at too. On SSDI for 4 to 5 years, can you get off of work full time again? You can do a trial work period, and then you can get into the extended period of eligibility. So yeah, they want to encourage people to try to work, but just what I always tell people is if you're going to work, don't work long enough to screw up your disability, but not enough to earn money to live on. So you want to just try it. That's why you have the trial work period. Um, I think integrity, you are skating on thin ice, my friend. Um, I don't know that every man is stronger than every woman. I wouldn't go there, but I think again we could say that a 250-pound man is probably stronger than a 90-pound woman who's 55 years old. I think we could say that. Um, okay, Ninja Mama. Can my sister claim me on taxes? We live together in SSDI. It pays more than half my expense. I don't know. I'm not a tax lawyer. Um, just do not know. I'm sorry. Not the right person to ask. I stay far away from taxes. Esoteric Fitness is a TBI survivor. We see him here every week. Good to see you, Esoteric, or I'll call you EF. Glad to have you here, and thank you for your time. Does it show on your MRI? The TBI, I guess. It's a good question. I don't know. Sometimes they do, sometimes they don't. Um, Usually there's something in the brain that will show there's been a bleed or some sort of a traumatic injury. I would say probably yes. That stalker, 45 years old, got to prove it on the initial. You got to prove in the initial app. Yeah, I think you aren't answering that question. Yeah, I think you can. There's a little bit of risk, but you can. Um, what about autoimmune diseases such as thyroid, or lupus, or fibro? Those are harder. I mean, again, thyroid can be measured because it's a hormone. Lupus, you might have there's a factor, in your blood that, it can tell certain things. Fibro is of the three the most difficult by far. I think that, thyroid and lupus are probably going to be little easier to prove than fibro. You're welcome, Debbie. I'm glad you were here. Okay, I figured that was much esoteric. You would have something would show in a brain MRI. Gemini to butterfly. I'm 50 and I had a stroke in 24. I have a hematoma. I guess a hematoma, diabetes, high blood pressure, to online application, stage 3 or 5, one chance to be approved as back pay. I think, pretty good, assuming that the stroke left you with some sort of permanent damage. That's the real question. Some people recover totally from strokes. And again, diabetes and high blood pressure, unless they're symptomatic, are not going to really help you that much. So having the stroke doesn't mean you're disabled. The after effects, and maybe medications you're on would have those impact. Melissa says you're an SSI from 2001 to 2018, but with a 5-year expedited reinstatement is possibly expedited. I don't think so. I think they're pretty strict about that 5-year reinstatement. I'm pretty sure. Again, I don't deal with that very much. That would be maybe a question that Greg Brinkley could answer. I don't know. Okay. Okay. I think we're all getting confused about the DUI and medications and so forth. Someone told me I'm most likely close to the initial decision on a psych CE and a next week medical. I would be careful about relying on what somebody told me. I just think it's Social Security. There's no, it's going to take as long as it takes for them to put the file together. And the fact that you've had the CEs basically says that they're working on it, but it doesn't give you any sense of a time frame. Annie Davis, my son got approved for SSDI on December of 23, onset date June of 23. I got first check in January of 24 when we went for Medicare. All right, the first check. So if he got onset date of June of 23, so you don't get paid for the 5-month waiting period does not start. It starts in July, August, September, October, November. So it sounds like December is the first month of eligibility. So I would say it's going to be December of 23. I would say January of 26 is when he's going to get Medicare. It's the 25th month after 24 months. So it's the 25th month. I think January of 26 is my thought. Judge has 51% approval rate. That's good. That's very good. Yes. That's great. What are you with an ALJ with 90%? Well, I got one coming up. So, there's not much you can do other than to assume you're going to have to appeal it. Not much you can do. Um, okay. Um, okay. Again, I think that was I think you were talking to me. So again, that was, we were all getting confused by the John and the DUIs and all that stuff. So, um, I, I think we probably, maybe people need to say, if they're referring to me, call it at Jonathan as opposed to at John. Um, yeah, I'd never heard of the Baker. They call it, there's different terms for it. There's a number, like I can't remember the number for involuntary commitment. Let's see, number, um, it's, there's I forget what it's called, like a 10 something, 1014 or something like that. My daughter is a bioethicist for a hospital chain. She's a lawyer and a bioethicist. And so she deals with a lot of people who are not competent because they have a medical issue, they have, there can be drugs, a number of things. And so there are times when they have to do an involuntary commitment, and I think it's like a 1041 or something like that. So it's the same thing as a Baker Act, but every state's going to call it something different. Florida calls it a Baker Act, so that's why it didn't ring a bell with me. It's just every state's going to be a little bit different, and quite frankly, I don't deal with that type of stuff very much. That's really more in an elder law situation. Um, Ticket to Work does exist. I don't know anything about it because everything I hear about it is people say it doesn't work very well. So um, I think esoteric I think you've been approved, have you not? Um, all right, Deb says fibromyalgia is not autoimmune. Now I always thought that it was. I mean, my understanding was that it's likely an autoimmune condition, but again, I don't, it's a lot of confusion about it. A lot of confusion about it. Okay. Yeah, I kind of agree with integrity. Some say it is now. Some lupus Hashimoto's would be considered autoimmune. Yes. Um, okay. Let's see here. All right. Just cause I can. I was going to call you just cause I can. But I realize it's just cause I can. Currently an SSDI, 27, got it due to meningitis that caused brain injury. Diagnosed with severe to major depression, psychotic episodes. Want to get back to work because of your children. Um, yeah, I think that, the trial work period would be a great way to test it. Great way to test it. And good for you. I think if you can, you should. Great question, that Stalker. That's a really, really good question. You were making 100,000 a year. Now your SSDI is going to be 3,400. Would that be a factor? No, does not factor in any way, shape, or form. To make an argument, well, why would somebody go for Social Security? They're making $100,000 a year. That doesn't prove they're disabled. It may go to their motivation, it may go to their sincerity, but it does not prove anything medically. And it's logical. I mean, why would you stop working if you're making six figures and sit at home for 2 years to collect Social Security? Where it could come into play would be if somebody is, been working for 30 years, making good money. A judge will see that, and it does enhance their credibility, but it is not a formal factor to prove that you're disabled. Um, Yeah, this is a good point. I mean, how do people wait for an answer for 2 years and not supposed to try to? And I think you can try to work. And again, I tell my clients now. I used to tell them no, don't work. It's really it's a black and white thing. Either you're disabled or you're not. But now it's like, look, if you can earn $1,000 a month, you're under your trial work period, you're under SGA. Judges have to just understand that this is as much as you could do. You have to prove that that's as much as you could do, but you got to survive. And I don't think, I think most judges that I've been in front of are aware that, when it's taking 2 to 3 years, that you may have to do something. Okay. Um, Melissa, this is my well, thank you, Melissa. I appreciate that very much. I'm glad you found the videos helpful. Very sweet of you to say that. Thank you. Really appreciate it. And I'll put this up one more time that if you, ooh, that's the wrong banner. I've got this little thing here on the live stream where I can put up different banners there. So like here's another one, the grid rules, and here's one. I could put more on there, but that's what I got right now. Okay. Glitzy girl, new here, waiting for an answer. I have to have some income. How many hours? Again, I think that, trial work period in 2025 is $1,160. SGA is 12, what is it? 1,500, 1,620. So I think that, to be safe, if you earn $1,000 a month, you're probably you're good to go, certainly. If you earn below SGA or let's say $1,500 a month, that's more than trial work period. A judge might look at that, but it's not going to disqualify you technically. It might be something you would have to answer why that's as much as you could make. A judge might ask him or herself, is there income suppression going on here? Could this person work harder, make more? That's the question. That's the question. Jenny Joe. Okay. Thank you, Jenny Joe. Okay. Spring Blossom. Fecal incontinence from surgery. Very good case. Fecal incontinence. Those are great cases. I mean, it sounds silly to say it that way, but you can't work. I mean, there's no way. So I take those cases. I got a bunch of those cases. They're almost everyone I can think of is one. All right, Netstalk was working as a vet, making 100 plus a year, no attorney, I'm 45 and got approved in the initial app. Didn't get approved because they could find me a job making close. No, you did not get approved because they couldn't find your job. That you got approved at 45 because you couldn't do anything. At 45, you have to prove you can't do anything. So if they thought you could be a greeter at Walmart, you're not disabled, even though you're a vet. So at 45, they had to prove you could not do anything at all. So it has nothing to do with your income. Esoteric CE is consultative evaluation. That's when Social Security sends you out to a doctor. All right, we're getting in close to 5 minutes left. All right, you're on SSDI. Can you sell on eBay? Yeah, you can sell on eBay. How much can you earn? Again, I think your earnings on eBay, I mean, like I said, SGA is $1,620 gross. Now I realize with eBay there's going to be costs. So you come off the top. Trial work period is $1,160. If you stay below trial work, you're going to be fine. And realize you can look at your gross receipts from eBay and reduce the cost of listing, cost of product. Are you going to really be making $1,000 a month on eBay? Or if so, how quickly? And also they're going to look at what you every day going out to stores and buying overstock. What are you doing? Is it a weekend thing? Is it a full-time thing? So I think you got to take all those things into place because SGA can be found even if you're not making money. If you're volunteering at a hospital or at a museum, that can be SGA. So if you're doing work for your eBay business and you're doing it 24, all right, say 24, you're doing it 10 hours a day, that sounds like SGA. Okay, what do you recommend a person to support themselves so they end up being homeless while applying? Like I said, I would say part-time work, sell things on eBay, cut your expenses to the bone. There is no good answer to that. This is a real problem. This is a real problem. David says, what is the appeal process if you get a denial from an ALJ hearing? You file within 60 days an appeal to the Appeals Council. The Appeals Council probably will affirm what the judge at the hearing did. Then you go to district court. But the Appeals Council, and you need to get an attorney to do that. I would do it on your own. Son got approved. You're welcome, Annie, for pulmonary arterial hypertension. I just had one of those cases. Strong case, no cure. Great. I'm glad that you won. Excellent. Excellent. Leave me a review. That would be awesome. Okay, let's go a few more questions here. And they hold you. They don't hold it against you to try to work. Nope. Full-time, well, again, you have 9 trial work period months. You can earn $1 million a month. So that's, you can, the first 9 months I'm not worried about. After that, you got to stay below SGA or otherwise you go to overpayment status and they'll cut you off. That's correct. Okay, John Zima. My neurologist is leaving the state soon. If I have copies of my medical evidence, how damaging my case, my doctor can't submit a medical storage statement. It's better if they could, but a lot of times you can't, doctors aren't going to do that, won't do it, can't do it. I think the medical evidence is probably more important, but if you can get it, that would be great. If not, maybe your next neurologist can take the records and formulate a statement for you that references the older records. Okay. 45-year-olds lost your hand saving a pet's life. Oh, wow. You're the veterinarian. Okay. So that's obviously why you can't be a vet. So, I assume that there's some PTSD involved, some other things. And wow, what do you say? That's crazy. 45 years old, lost your hand. Um, so obviously, there was enough there to show you could not do any kind of work. Um, Very interesting, though. Um, I filed for disability after official time limit paid only 1 month. How best to appeal this? I'm not sure if I understand your question. I don't understand the question. Yes, I understand you lost your hand. Yeah, I get it. I understand that. And obviously that's going to eliminate work as a vet. The question is, I'd be curious as to what the rationale was, because obviously there are jobs that one can do with one hand. It limits them. There's less jobs you could do with one hand. But the question is, what was the basis of the approval? Obviously, part of it was physical. Was there a mental health component to it? Is there something else going on? Because I suspect that there are jobs you can do with one hand. So that alone, I'm thinking, and although, when I think about it, the listing might talk about, the musculoskeletal listing one might talk about loss of, you know, a part of an upper extremity. So maybe you met the listing. Very interesting. Okay. All right, I'm going to make this the last question. Dennis says, my lawyer received over the max on my case, $7,200, which now is changed, by the way. It's $9,200. But they returned the overage for my son's auxiliary if they paid over to them. If they overpay, the attorney will get a letter saying you need to repay this. This happened to me last month. I got paid. They overpaid. They paid me more than $2,000 more than they should have. I checked it out. It was correct. I sent them $2,000 back. That's what you got to do. What you got to do. Harrison, why don't they focus on making SSDI a solvent in the area of options? Yeah, I mean, there are ways to do it, but they got to have the political will to do it. With testimony from witnesses by psychosis and early childhood abuse, yeah, I think that would certainly be very relevant. Absolutely, absolutely very relevant. Ned Stalker, my pleasure, Ned Stalker, and thank you. And again, I have a lot of respect for vets because I have a big old goofy dog, 75-pound golden doodle, who's very sweet. But look, every animal is unpredictable. I don't know what animal got your hand. Obviously something with a lot of jaw power. But my point is that as a vet, you're not dealing with logical beings like you are with human beings. Not that a human being couldn't attack you, but you don't know. You get a pit bull in there who's as sweet as can be and sweet dog to 5-year-olds, and you move the wrong way, and that pit bull takes your hand off. Or maybe you're doing more exotic animals. I mean, I don't know. So, I think that it's a calling. And most vets I know are just really neat. I know a number of them, really neat people. So, kudos to you for doing that for as long as you did. And I'm sorry that you can't do it anymore. Maybe you can find something you could do in a consulting fashion that use your knowledge to help. I had actually a vet, a woman write me, was asking some questions about some things. We corresponded a little bit. I think she had been a vet. It was very interesting. It's some great stories, really interesting stories. Okay. All right, so let's end it here. It's 10:30 my time. We've been about 2 hours, so as always, I appreciate everybody for tuning in. Again, I'm working on getting some really interesting guests coming on. Um, and we'll maybe get, like I said, I've got a judge who told me he'll come on, try to get him on soon, and we can ask some of those questions about, like one about the appeal. If you get an order from the appeals council, does that make you more likely to want to approve, and just what his take on it would be. So we'll find out. But anyway, thanks everybody. Hope you have a great evening, great week. Hope it's warm where you are. You have a healthy weekend, that you are healthy, and that again, if you need me, look at the crawl on the bottom. Just contact me. There's how to do it. And if this was helpful, please do leave me a review. So for now, this is Jonathan signing off. I'll see you next week. Take care. Bye bye.